Hello everyone, thanks for joining us today. I'm Nate Duncan. I'm a product analyst in TMG's Product Development Department. And today we're going to be talking about the Telephone Consumer Protection Act, or TCPA, as it is affectionately known. And we are going to try to provide you with an overview of the TCPA Act and everything it means for you, and just try to get you familiar with the ins and outs. TMG has been working diligently with PolicyWorks and to become more familiar and try to take steps to become more compliant and meet the TCPA requirements. So with that, I am going to hand it off to the Vice President of Regulatory Compliance, Cindy Williams, and she is going to take you through the TCPA and what it means for you.
Great, thanks Nate. So we are just going to jump right in here and start out first with just a little bit of a background of what the TCPA is. It's been around since 1991, so this is actually the 25th anniversary of the TCPA. And basically, when it was first implemented, the idea behind it is that it made it unlawful to use the telephone or recorded systems to solicit individuals for marketing purposes without their permission. So that's kind of how it all started. And over the years, there have been changes that have taken place, but there were some very significant changes that actually took effect in October of 2013. And they were so significant that it was actually a little bit confusing, some of the new requirements in those changes. So in 2015, in July of last year, the FCC issued what they called a declaratory ruling regarding some of the questions related to the 2013 changes. And that ruling had some very new and very different interpretations, and so that's really the piece that we will sort of concentrate on today. And as far as the TCPA goes, all of the rules in the TCPA apply to landlines, wireless phones, and text messages. So first let's look at the risks and the penalties associated with this. And the interesting thing about the TCPA is that there is less of a regulatory risk and more of a financial risk associated with it, because it's probably fairly unlikely that the FCC would come into your location and actually want to conduct an exam. What is more likely is that you could be subject to lawsuits or even class action lawsuits. So the rule itself has some penalties built into it. There is a $500 penalty for each unintentional violation and a $1,500 penalty for willing or known violations. And each call is considered a violation. So this can add up pretty quickly. There's no cap on damages in a lawsuit, so there's certainly a potential for some pretty staggering damage awards. And there's also potential for fees, attorney fees on both sides. So this has really contributed to the increase in this because it's become sort of a popular lawsuit to initiate on behalf of attorneys. In 2015 alone, there were over 3,700 lawsuits associated with the TCPA. So you can see this is really where the risk lies. So let's talk about some of the key points of the 2015 ruling. So first of all, a very main piece of it is that consumers must provide express written consent to be contacted using an auto dialer. And I think the term auto dialer has a lot of confusion about it, and I'm going to talk about that a little bit more on the next slide. A second key point to the 2015 ruling is that consumers have the right to revoke consent to receive calls and text messages in any reasonable way at any time. And when it says in any reasonable way, this means the consumer gets to choose. the method that they want to use to revoke consent. So we are not able to prescribe what that should look like. They are able to decide how they want to revoke consent, and then we have to comply with that. And then finally, the last major point of the 2015 ruling is that callers are required to stop calling a reassigned wireless number after a single call. And I will talk a little bit more about what that means as well in another slide. So let's talk about autodialer. This has really created a lot of confusion. So in the rule, basically the definition of an autodialer is equipment that has the ability to store or produce telephone numbers using a random or sequential number generator. And here's the tricky part. It also includes any equipment that potentially in the future could have this capability. So it doesn't have to have that capability now, but it could have that capability in the future. So as far as defining what that means, in the rule, there's actually a statement that says, basically the only exemption to this definition is a rotary dial telephone. So any other phone, any other process, even if it's being manually dialed, still meets this definition of autodialer. So if you want to avoid that definition, the only way to do it is get on eBay and find one of those rotary dial phones, because that's the only exemption. And it even actually also includes internet to phone text messages. So the bottom line is any method that you are using will be considered an autodialer. So another challenge is this idea of prior express written consent. So the rule sort of defines what that looks like and what should be included in prior express written consent. And we have to have this if we want to be able to contact a card holder. So first, it has to be in writing, it has to be signed, and it has to show the following. It has to be clear and conspicuous. So those of you who are involved in regulatory compliance know that that's a very familiar phrase. So it has to be clear and conspicuous, and it has to state that the consumer will receive calls that are delivered using that are delivered as pre-recorded messages. Now, even though it says pre-recorded, this does not actually mean the messages have to be pre-recorded. So kind of like the definition of autodialer, this is all-inclusive. So this is going to cover any message that you might want to deliver. It should also include a statement that the consumer agrees to receive calls at the number that they have designated. So in other words, this is going to include a designation by the card holder of the phone number that can be used. It needs to have a signature, and this can follow the requirements of e-sign, which I will also talk about in a moment. And there has to be a statement that the card holder is not required to provide this consent as a condition of purchasing or receiving any good or service. So now let's talk a minute about what the actual requirements are for the consent, what this consent has to include. So this really can be kind of a checklist for you if you are wanting to create a consent document. So first, it needs to describe the types of messages covered by the consent. It needs to state that the messages will be made using an automatic telephone dialing system. It needs to include the specific phone numbers that the customer or your card holder is authorizing messages to be delivered to. It needs to state that the card holder is not required to provide consent in order to receive goods or services. It must also state that they have an ability to opt out of this consent at any time. And then it does require a signature of the consumer, the card holder. And as I mentioned, this can use the e-sign rule in order to obtain this. And if you're not familiar with e-sign, e-sign is an electronic signature. which means that you can obtain this through the internet. You can actually obtain this through a recorded voice message. There are multiple ways that this signature can be obtained under e-sign. And then finally, the last requirement is that you cannot use any pre-checked boxes on the consent. So in order to assist the cardholder, perhaps you might think it would be helpful to go ahead and check some boxes for them, but the rule specifically says that you cannot use pre-checked boxes in the consent form. So here are some examples of the ways that you can obtain written consent. You can obtain it through email as long as it conforms to e-sign requirements. You can obtain it through a website form. And again, using these types of methods mean that you need to have some kind of an authentication component to the signature. So if it's a website form, typically what I've seen is that financial institutions are using this within online banking, where they have actually been authenticated as they're going into that, so that when they sign the form, then they can be assured that the person who consented is actually who they say they are. It can be done through key press methods on a telephone, again, assuming you have some authentication methods in place. And then, as I mentioned, you can also use voice recordings. So while these don't seem to be written methods, they actually do fall under e-sign as methods that meet the same standards as if a signature was in writing. And one thing I think is important to understand is that there have been a number of financial institutions that have asked me whether or not they can just build this into their account agreement. And the FCC specifically stated in the rule that putting it in an account agreement is not a sufficient method of obtaining express written consent. Even if it's separate, if it's a separate area, it still does not meet the requirements. So it's really not recommended that you just simply insert this into your account agreement. So there are a very few number of exceptions related to TCPA, and you'll probably recognize these as I talk about them because you've probably received some of these kinds of calls. So these are the calls that can be made without prior express written consent. So the first is a call that's by or on behalf of a tax-exempt nonprofit organization. So these are those phone calls that you might get where they're seeking donations for an organization. Secondly, calls for political purposes. So these are exempt. So you probably are familiar with those as well. Even if you are on a do not call list, you can still receive these kinds of messages. And then calls for other types of non-commercial purposes. Those are all exempt. So there is no prior consent required to landline customers for these types of calls. Now, one thing that they did eventually build in is that there needs to be a verbal consent to wireless consumers to receive these calls. And the reason for that is when cell phones first became popular, they were often, the calls that you received were actually, you were charged by the call. And so they were concerned that consumers were receiving these calls and were being charged for those calls without their consent. So after a period of time, they did change the rule and build in a requirement that at least verbal consent for these kinds of calls was required for cell phones. Next, I want to talk about reassigned cell phone numbers, and this is a kind of a challenge. So basically the rule says if a consumer is consented to receive calls or text messages, and that number is later reassigned to someone else who has not consented to receive those calls or text messages, you can only make one phone call to that number before you have violated the TCPA. And this is challenging because there is no requirement that the caller know or have reason to know that the number has been assigned. So even if that call is not answered, you may not call that phone number again without violating the TCPA. And the idea is that the recipient must be the person who provided consent. So even if you have no knowledge that the number has been reassigned, you could potentially be in violation of the TCPA. So this one is going to be a challenge. Text messages, a one-time text in response to a request for information does not violate the TCPA if it was sent in response to a consumer request for information. So if they ask for information, you can send a one-time text and not violate the TCPA. And also in the rule, this may or may not apply to you, but if you do have consents in place that were obtained prior to October 2013, they are no longer in effect. So in other words, if you are relying on a consent that's older than that time frame, you would need to obtain a new consent. So here are a couple of exceptions that are a little bit helpful for us. If there are urgent circumstances, such as fraud or identity theft, we are allowed to contact a consumer without their consent if there is no cost to the consumer for that call or that text message. So this is where text messages will be tricky, because there are still some cell phone plans that do charge for text messages. So you may not know whether or not that's the case, so you're going to have to be careful using text messages. But outside of that, you do have the ability to contact a card holder in the event of fraud or identity theft. Now, they do still have the right to opt out of these kinds of messages. So if you do contact a card holder and they say, I choose not to receive these, they have the ability to opt out. We can't include any kind of marketing or debt collection in these calls, and we can make no more than 3 of these calls or text messages per day. Now, there are some record-keeping requirements related to the TCPA. So first, if you obtain written consent, you have to retain that. And that will include any kind of recorded phone calls that you have received consent. Whatever the method was, you do need to retain those written consents and opt in. So there are a few legislative updates actually taking place because this is fairly onerous on the businesses and entities that must comply with this. So there are now some legislative hearings, there are some lawsuits that are taking place, and there was actually just a hearing on May 16th of this year with the Senate Commerce Committee, and at that time there were a number of trade associations and businesses who presented information on the impact that this is having on being able to contact their customers. One of the comments that was made on behalf of financial institutions is that it's having a detrimental impact on consumers by preventing financial institutions from being able to send important or time-sensitive messages. And there were actually a number of various speakers who presented information asking that the rule either be vacated, in other words, rescinded, or that it be reformed in some way. And there have also, as I mentioned, been a number of lawsuits that have actually been filed against the FCC and are awaiting court dates. So there is a potential. There could be changes coming. There's no guarantee for it. And when the declaratory ruling was actually made last summer by the FCC board, there are 5 individuals on that board, and it was a vote of 3-2 to pass this declaratory ruling. So it wasn't even a unanimous vote among the FCC board members that this is actually a good rule that needed to be implemented. So we'll wait and see. There may be some changes that are coming down the road. So in summary, the TCPA is a very complex rule. There are a lot of moving parts to it. For those who have to abide by the rule, the very conservative approach to the Act is that taking best practices due to the significant risk of litigation and penalties. So taking a conservative approach to this, it's probably not a best practice to try and sort of live on the edge of the rule until we find out where the dust settles with some of this. And I would recommend to continue to work with your trade associations and your legislators to try and provide anecdotal information to them about the consequences that you're seeing related to this act and to this declaratory ruling. So that concludes the presentation for today. I hope you found this informative. And as you move forward with this, please feel free to contact TMG or PolicyWorks with questions you might have.